Thank you, Wendy. In a 91-page judgment delivered in the High Court this morning, Dr. the Honorable Justice H. Patrick Wells ruled that both the verdict and the proceedings at the inquest shall stand, and that any injunction granted in the matter previously was fully discharged immediately. In ruling against the claim for judicial review brought by Dr. Shiley Griffith, Justice Wells declared that Dr. Griffith had failed to establish that the coroner acted with bias, or that the coroner deprived him of any rights that he would be entitled to under the principles of natural justice or under the Constitution. Justice Wells further ruled that no illegality was committed by the coroner, as he followed the law in taking the evidence that was presented. He determined what evidence he found persuasive. He assessed the credibility of witnesses as he was entitled to do as a finder of fact, and then he duly delivered a verdict as he was compelled to do under the Coroner's Act. One of the complaints made by Dr. Griffith was that he was named by the coroner in the verdict and was accused of manslaughter. But Justice Wells ruled that the coroner did no such thing and that he had simply stated who was criminally concerned as required under the legislation. In response to a suggestion by counsel for Dr. Griffith that the verdict of the coroner would cause the Director of Public Prosecutions to have to criminally charge Dr. Griffith, Justice Wells ruled that the Constitution was crystal clear on the independence and authority of the DPP and that the coroner's verdict was binding on no one, including the DPP. In addressing the reasonableness of the verdict reached by the coroner, Justice Wells cited certain facts from the record and determined that what the coroner decided was supportable by the evidence he had heard and was not outside of the realm of the possible findings that could have been made. In relation to a further complaint by Dr. Griffith that the coroner could not find facts, Justice Wells dismissed this argument, indicating that it would be impossible for any court to render a verdict or a decision without making findings of fact. In relation to an application that was made in the proceedings for him to recuse himself because he had promised a prompt ruling in the case and had dealt with another matter involving Dr. Griffith before the court for case management purposes, Justice Wells ruled that the recusal application had absolutely no merit as no evidence was presented to the court to support the application. Justice Wells also cautioned against making recusal applications lightly, as such applications had significant implications for the integrity of judicial officers, the integrity of the proper administration of justice, the rule of law, and the abuse of process of the court. The matter concluded today after a trial late last year. Wendy, reporting for CBC News, I'm Rasheed Best.